as to bond.
Well, I don't know what Sonna's bond argument is going to be. I'm not happy about that, but Mr. Mikowski Smith comes before your honor. He's a very young man with no history of assaultive offenses. He lives at home locally. He works a 40-hour-a-week job at Slim's Chicken. I know after I'm done speaking, Ms. Senna is going to get up and read the police report, and it might
You
not.
don't know that.
I
Get
have a
with your, go with your.
Okay. Okay.
You state your name, sir.
Elon Bankhead.
Thank you.
Beginner, we are waiting to receive and review media discovery, so I'm going to need a adjournment of the probable cause conference, please.
All right. How much time have you received it as of yet? Is that a green sheet?
It is a green sheet. Not yet. Ms. Zinda believes that she released something to us. We don't have it on our end. I don't know if it's our end or their end, but we are in communication about it. And we're going to.
Ms. Zinda said she did it, then it's your end.
I believe that as well, Your
Just
Honor.
saying.
To make sure it'll be released. We have it. It'll be released. Right.
Gotcha.
And address bond, Your Honor. Appropriate.
Yes.
Yes, Mr. Bankhead would like me to ask for a reduction in bond, Your Honor.
Hold on one moment.
Sure.
So you're going to get that released. How much time are you going to need to review that?
I'd ask for the shortest possible adjournment, Your Honor. Mr. Bankhead's very motivated.
Probable cause conference, January 30th, 2025, 9 a.m. All right, go ahead. Bond.
Well, I don't know. Did you have something?
Your Honor, we would be addressing the defendant's phone privileges and be asking that they be revoked. He's making calls to not the victim, but we believe other family members and saying things like, tell her, make sure you know who, don't make sure she don't show up to court. And the more she don't come to court, we good. Other calls, he says, can you tell my mom, make sure you don't come to court, get in contact with Marquisha, the victim. Tell her if she really wants to be with me, go to call the prosecuting attorney, tell her to drop all this expletive. Tell them, do everything she does and she's getting off this. I don't care anymore. If she really wants to be with me, call her and tell her to drop all this. Other people contact the victim and telling her to not come to court to drop the charges.
Your Honor, this is the first I'm hearing of it. I would ask that the court not revoke his phone privileges until I'm able to review the calls.
His bond will continue at this point. Defendant's phone privileges are revoked pending a hearing.
Thank you, Your Honor.
Morning, I'm Robert J. Columbia, Taylor Lewis. Taylor, would you state your name for the record?
Taylor Lewis.
Thank you.
Judge, I was just appointed this
Oh,
case. We're asking to adjourn the PCC.
Probable cause conference in this matter will be adjourned to February 6th.
Judge, I'm going to be in the middle of, I think my CSC trial is probably going to go most of the.
February 13th.
Thank you, Judge. Appreciate it.
No, you don't. 2025, 9
Really do,
a.m.
Judge.
Bond continues.
Oh, Judge, just one quick note. She's a top chef. She's been on tether.
She's what?
She's a top chef at Ford's. She is on a GPS tether. She's only been on it 2 weeks. There's been no violations. It's hindering her work. She lives nowhere near the alleged victim in this matter, and she's asking if the court would please consider. She seems like a very honest woman to me that she will have.
What way is it?
Pardon me?
What way is it hindering work?
because I'm actually kind of the face of my job. All my other employees, everybody works kind of the back. I'm the one that's serving food. So my boss yesterday told me just, hey, it's not really a good look for the company with me walking around with the tether, kind of serving clients of different businesses and different clients we have, dropping off orders that I pretty much I deal with. I deal with all the ordering and different things.
Response.
Your Honor, we would object to any modification of the bond. Given the facts of this case, the defendant broke into the victim's residence while she was out of town, threw bleach on her clothes and damaged them. Also, stole $350. We feel a tether is extremely appropriate.
Judge, again, I'm not to argue the case here. That's just a bunch of baloney. This lady was invited over there. It was a past relationship, and she went over there. The lady told her where to go into the house. Nothing was taken. Nothing was destroyed. She lives nowhere near this lady. She's a hardworking lady. I don't want to lose her job. Would you please?
Well, I don't want her to lose her job either, but I think You're saying she was invited over. That's not the facts that we have in this case.
There, Judge,
Invitation.
when we hold the exam, there will be texts shown that she was invited over there. She went over there, there was nobody home, she left. All of a sudden now, later, that says this is taken, this.
Well, if you have those messages, I'll consider them, but I don't have them in front of me.
Yes, sir, I
I
do.
don't have them in front of me at this point. So certainly you can raise that before me, Mr. Killawall, get it to the prosecutor. We'll take a look at it.
Yes, sir.
But at this point, motion for bond reduction is denied.
Thanks, Judge.
Somebody could do this.
Judge, I was just appointed on the case. I talked to her last night. She said,
I heard that.
and she said she sent me the text messages. I will forward to the prosecutor and to your honor. And hopefully you'll change your mind,
Your Honor, may I speak or? you
just
know?
real quick.
Am I able to?
I guess he gave my answer. Go ahead.
Okay, sorry. So just really quick, I was in touch with, another attorney, so he was, of course, just appointed to me. My other attorney, I have sent them all the text message proof. She has tried to contact me through everybody else even around.
Ooh,
My ex-girlfriend, we used to live together, and pretty much we used to live together. We had a breakup where I stopped having contact with her. We were actually raising a child together. So she pretty much lured me by blowing up my phone, literally, I mean, every single day up until I went over there saying to come over.
Man, I understand. I may understand all of that.
Yes,
What I'm indicating is that I don't have anything to the contrary of what I have. If you send it off to another attorney, you need to get it from them and get it to Mr. Killawall
yes,
so
sir.
he can do what he just said he was gonna do.
Yes, sir. I was asking because I live nowhere near this area.
I
So I'm
heard that
asking,
also.
yes, am I able to show the messages to him today to be able to show to you today? You know,
I think that if you get them to your attorney will then make the decision as to getting them to the prosecutor and then how to get them to the court.
yes, sir.
we'll do that today.
Anything
Okay,
else?
yes, sir. Yes, sir.
Thanks, Judge. We do appreciate your consideration in this matter.
Yes.
Thank you.
Thank you.
Yes, same.
Good afternoon, Your Honor. Good afternoon. Good morning, Your Honor. Rob J. Hill on behalf of Mr. Dawson.
Your name, sir?
Messiah Dawson.
Thank you.
Judge, in this matter, I'd like to set an exam in this matter, and if I may address bond.
Is all discovery complete?
I believe so, Your Honor.
People have their witnesses available February 4th. February 11th.
No, oh, that'd be fine.
Preliminary examination in person, February 11th, 2025, 9 a.m. in person before Judge Alvo.
Thanks, Your Honor.
Judge, just as to bond, this young man, if you recall, you told him to test. He lives in Detroit. There was some issue of, and I remember this, the court, not you and I discussing that we were going to try and find a testing facility closer to the Detroit area where he was living. That was the issue of him not testing. We would renew that request. I believe that's the only reason that this young man is now in jail. And we would ask for a PR bond. And
Well, I would permit him to test there, but he didn't test. He's got to sign the release. We have no information.
well, Judge, he was trying to test here, get rides up to here. He showed up late. They refused to test him. Quite frankly, I think, and then he just didn't test, but it wasn't because he didn't want to test. I think if you tested him, that he would be clean and that he's willing to follow the court orders if he can get a testing facility in Detroit. I'm just asking if you
Find a
get,
testing facility and it needs the approval. You can either get mine or Judge Valvo's signature on it. I don't have a problem with that. And then I'll let Judge Valvo, since it's her case now, set the bond, or if you need to get it before me, I'll deal with it.
so if we find a testing facility, you would
That is approved by Community Corrections. I do not have a problem. I just want a certain level of testing.
what's that?
We're gonna come on.
And he has to sign a release.
Come on, girl.
He's now saying, Judge, if that he'll get a ride out here, he'd like to be out of jail, obviously.
I know, but we tried that and that didn't work. So which way do you want it? It's either gonna be, he's gonna test here or he's gonna,
Well, if you're gonna make a commitment to test here, you can't fail.
Come on, girl.
Judge, he said he's willing to,
then doesn't test and we're back here doing this again.
well, if he's selling the court.
I just said what I said. Bond continue.
Thank you.
Thank
Your
you.
Honor. Thank you, Your Honor.
Court does call the case of the people versus the Marion Markowski Smith.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Mikowski Smith is coming up to the podium. Please state your name for the judge.
Demario Markowski Smith. Thank you.
Your Honor, I'm hoping to set this case for preliminary examination. Discovery is complete. I'm also hoping to address bond as well.
Your Honor, we would also include that on the appropriate.
Surprise.
People have their witnesses available on the 4th.
Your Honor.
Preliminary examination in this matter in person will be set February 4th, 2025, 9 a.m. before Judge Fresh Hour. As to bond.
Well, I don't know what Consenta's bond argument is going to be. I'm not happy about that, but Mr. Mikowski Smith comes before Your Honor. He's a very young man with no history of assaultive offenses. He lives at home locally. He works a 40-hour-a-week job at Slim's Chicken. I know after I'm done speaking, Ms. Senna is going to get up and read the police report, and it might
You
not.
don't know that.
I
Go with your.
Okay. Nevertheless, Mr. Mikowski Smith, if the court is gracious enough to consider releasing him, he will go home. He will stay home, with the exception of going to court, going to work, and that's it, Your Honor.
Counsel.
Your Honor, at this time, we would be asking that the defendant's phone privileges be revoked. He's been contacting his mom and telling her to contact the victim, saying things like, I got put at 10 in the morning, they already told me, and if I get convicted, it's a felony myself, so I definitely need to talk to them on that. He also says, like right now today, you gotta let her know, like if she, oh my God, when we get off the phone, I need you to call over there immediately. And then he says, you make sure what's her name knows not to come at all. Basically, nobody for okay, I'm good. So try to let that be known. Just try to let that be known so that it's contact the victim from third parties.
And I doubt any of that was in the police report, so she didn't read it. Response.
I have no response here.
Motion for bond reduction is denied. Phone privileges are revoked. You can ask for a hearing if you'd like. Thank you.
Your Honor.
Court does call the case. People versus Benjamin Detlef. Detlef, can you state your name?
Yes, Benjamin Detlef's here for the court, Your Honor.
All right, thank you.
Thank you.
Thank you. Your Honor, we are asking for an adjournment of this matter. And I'm surprised to see him in the solitary, Your Honor. When I spoke to him yesterday, he was doing pretty good.
All right, you want? I'll adjourn it for you.
February 20th.
Hearing will be adjourned February 6th.
February.
And trial in his other PCC.
He is.
Yeah.
Gotcha. Thank you.
Your Honor, I would like to, and I see that he's being held right now, but I would like to address bond in this matter. So my client was found not competent.
Hold on. Is he being held on the other matter? Okay, silence. That means I asked a good question.
You asked a really good question, Your Honor.
Yes, he is held on the other matter until February 20th on a $1,000 bond. The bond in this case is $100. The felonious assault. It is PCC.
Your Honor, I'm still going to address bond, and if the court would allow me to, please.
Yeah, go for it.
And I understand the court's position here, but my client was,
What do you mean you understand my position? I'm saying he's held on another case, so I don't know what you want me to do.
Your Honor, I want to get this. Will the court please just indulge me for a moment? I want to address bond.
Apparently, I don't have a choice. Go ahead.
The reason why he was being held in the first place was on the case out of the 15th, where he had been found not competent, and they did a involuntary commitment order, but they found him not competent, and the case was dismissed. And since then, my client has just been held and held and held and held. And while he's been held because he's not competent, because he has mental health issues, he's collecting these cases. Your Honor, I don't understand how he was still held after the case from the 15th district court was dismissed.
I don't know, but he's held on another matter at this point, right? What is that other matter?
Assault case. Which case file are you talking about? Because the FA case that he's in custody is a 15th case that has
been dismissed. Do you have a case file for the dismissed 15 case number?
Your Honor, I actually put it on my notice to request the adjournment.
24-1311 SM, that would not be a felony case.
Is that the case he's been calling? That's the only one.
That's not the case he's being held on.
Okay.
Held on is 24 F5 5228.
Thank you, Your Honor. And I'll look into that as well. But again,
And that's an assault that he committed in the jail before his 15th case was dismissed. So he was in custody on the 15th case that you're now saying has been dismissed.
has been dismissed, yes.
He assaulted somebody in the jail before that 15th case was dismissed, and he is in custody for that September assault.
Which may explain why he wasn't released.
Thank you, Your Honor.
Motion for bond reduction denied. Bond will continue. Did I give a date already?
Thank you, Your Honor.
I'll adjourn the matter to February 6th, or February 20th, I'm sorry, 2025, 9 a.m. Go along with this other case. Bond will continue.
Ready, Judge. Torshell Feaster, Assistant Public Defender, appearing on behalf of Mr. Driscoll. Mr. Driscoll is approaching the podium, Your Honor. Put your name for the record.
My name is Jeremiah David Driscoll.
Thank you.
Thank you, Judge. Mr. Driscoll would very much like to get this matter resolved as quickly as possible. I spoke to Ms. Zinda about it. At this time, there isn't an offer yet. She's had to speak to the victim in this case.
How did your conversation with Ms. Indigo?
Well,
Did she just
pleasant.
repeat the police report to you?
No,
No, I just thought I'd
she
ask.
didn't have to, Judge.
I just thought I'd ask, because that's what I'm here.
Oh, no, she didn't.
Oh, okay. All right. That's what I thought. I
She's
didn't
very
think she
pleasant.
did that. I just thought I'd ask.
So my client wants to get it resolved as quickly as possible. He's
All
asking
right.
for a 1 week adjournment if the court granted, but I told him the court would.
Are you gonna be able to get it done in 1 week?
She'll talk to the victim, I'm sure, within a week and let me know if they're.
Oh, that was cordial.
Thank you, Ms.
And
Zinni.
again, it had nothing to do with the police report. The 30th.
Thank you, Judge. Next week. And I do not have a bond argument. Thank you.
What'd you say?
I do not have a bond argument.
You don't? Okay,
Oh,
good.
now he does.
He does now?
Yes, Judge. My client is asking Your Honor to consider a personal bond in this matter. He says he does not have a violent record and he would like to be able to be released. But we talked about this in holding. I told him if you give him a 1 week adjournment, you're unlikely to change the bond. But he is asking that you change it anyway.
Okay, now here we go. Miss Linda.
Given the defendant's history, he has a DV from 05 and multiple, or a dismissed DV, child abuse fourth, and 2 A&Vs. In this case, they had been dating 2 years and the victim was 3 months pregnant with his child. He was upset that she wasn't getting an abortion, stated, "You're not gonna get rid of that baby," and pulled out a folding knife on her. She went to the bathroom, locked the door, and called 911. She then attempted to leave the store that she was working at, grabbed her by the throat, he then headbutted her. He then began to demand that she give him her phone as she was calling 911 and was pulling her across the floor of the store by her hair before fleeing. Immediately after fleeing, he then called 911 himself to say she was making a false report and that he was in Detroit, when in reality, it was shown that he was in Ipsy. Her dispatch is at House of Liquor. Do you have facts in this case, Your Honor?
Nothing conditional, Your Honor.
I'm surprised this bond is actually so low, but I'll leave it where it is at this point in time. Motion for bond reduction is denied.
Thank you, Judge.
Bond will continue. Court recalls the cases of the people versus Brandon Hampton.
Your Honor, sorry. Ashley Bashir on behalf of Mr. Hampton. And in addition to addressing the case directly, we would like to address bond and request that a condition, specifically the home confinement tether, be reconsidered.
Okay, I'll get to that maybe at some point.
So thank you. Yeah,
Right now, I'm trying to get these pleas done.
thank you.
So my understanding is he's gonna plead to count in case ending in 1596. He's going to plead to count 2.
Yes,
Correct? With count 1 being dismissed. That's gonna be a guilty plea. Correct, counsel?
Yes.
All right. Then on the other matter, I have a plea form that indicates that the defendant will be pleading guilty to an added count two of attempted resisting and obstructing the 1 year offense. Upon a successful plea to that charge, count one, the resisting and obstructing would be dismissed. And there is an agreement that the defendant is to go to mental health court. That's the court's full understanding of the agreement.
That's right, Your Honor.
May I have the defendant sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Brandon Hampton.
Man, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Yes.
All right. The first one in the case ending in 1596 is the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Mhm.
Yes?
Yeah.
Okay. You also understand in that case that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yeah.
Okay. And understanding that on that case, do you still wish to plead guilty?
Yes.
All right. On the other case, it says court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Why are the judges different, Your Honor?
Why are the judges different? Because these allegedly occurred in two separate places. The case that we're just talking about with Judge Valvo, the offense took place in the city of Ann Arbor. And the other case happened in maybe the city of Ypsilanti or, yes, in Ypsi City of Ypsilanti. I'm sorry, Ann Arbor Township. Okay, so they occurred in 2 separate jurisdictions. Okay, that's why you have 2 separate judges. But what's going to happen, I think this is probably really the crux of your question. You're going to go to mental health court on these, right?
Yeah.
So Judge Valvo is actually in charge of mental health court. So when that case goes over to her, that will be where it is. You'll have to go before Judge Barr. Judge Barr will do the initial part of the sentencing and then place you on probation to be supervised by the mental health court. Follow that? So it's just a little bit of a process. Both cases, it's anticipated, are going to end up in the same spot.
Okay.
Okay. You got that? Any other questions on that?
I guess it's not like possible for the other case just to go to Valvo as well.
It will get there. It just can't go directly that way.
Okay.
Okay.
For sure.
Anything else? Trust me, we do this all the time. It'll get there. So it'll catch right up to it. Okay. All right. Any other questions you have?
Just the one about bond, but
yeah, we'll get to that in a moment. All right. So understanding all of that, you still wish to plead guilty to these charges?
Yeah.
Okay. So to the charge of aggravated assault, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yeah.
All right. You signed an advice of rights form, correct?
Yeah.
Do you have any questions regarding any of those rights?
No.
All right. You see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yeah.
Were you on probation at the time of these offenses?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
All right. Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
No,
Mr. Hampton, so,
tell you what, why don't we pass the matter? Maybe you can talk to him and we'll give this another shot today if we're comfortable with it. Otherwise, the court may not be comfortable with it, and we might just blow all of this up and it'll just have to happen another way.
thank you. Your
But
Honor.
I'll give you a chance to talk.
We appreciate that. Thank you, Your Honor.
We're back on the record in the case of the people versus Hampton. We're in the middle of taking a plea. And so I stated the terms on the record. And Mr. Hampton, I'm going to ask you a couple questions again. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No,
Has anybody threatened you or coerced you in any way to get you to plead?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you're guilty of these offenses?
yes.
All right. We'll start with case 1596. Paperwork, it's all right in place here, but this is the aggravated assault case. Okay, Mr. Hampton, on the date of August 29, 2024, at Washtenaw Community College in Ann Arbor Township, Washtenaw County, State of Michigan, do you recall what happened on that date regarding a Vladimir, is it Parahorov?
I don't know, Your Honor.
All right, did you get into a fight with somebody?
Oh, I know what happened. I don't know what his name is. It sounded like.
Okay, why don't you tell me what happened then?
Oh, I was trying to take a shower, Your Honor.
Okay, and then what occurred?
When I was in the locker room, he had pushed me up against the wall, hit me in my head, and threw me on the ground, and then broke in my property.
Okay, but before that, did you do anything before that?
No,
Okay.
it wasn't until there were 4 people on top of me, and I was fearing for my life that I bit him, Your Honor.
Okay, so here's what I'll do. Counsel, because I can see the way that this plea's going, it's not gonna work. So if you guys want to change, I'm not suggesting if you guys want to change things to a no contest. If you want to do whatever, what I will do is I'm back up at 1. I'll call it back up at 1. I think everybody's still going to be here. So, and give you a chance to talk with him, decide whether or not you want to do no contest, please explain what a no contest, go through all of that with him, and then see if we can get this done.
Thank you very, very much, Your Honor. Appreciate it. Thank you.
This is a prime example for me of no good deed goes unpunished. All right, so we'll call it back up at that point. Quarter past these matters again.
We can see, I'd be happy to file a stip to adjourn that, the exam or for the other case.
Well, you're gonna need a step on the exam.
Yes.
Because I only took it because there was gonna be a plea. When do you want the other one adjourned to?
When is the soonest?
I'll set this, I'll adjourn the
After the 13th.
1596. I'll adjourn 1596 to February 6th. The other one is stay on track for a preliminary examination. I understand that people are not going to have their witnesses available, or you need a stipulation to adjourn that out.
Okay, thank you.
Okay.
Thank you, Your Honor.